Okay, so let's go ahead and get started. Feel free to enter the questions into the software, and I'll be kind of monitoring that. And I may or may not pause to go through them, but feel free to try and keep this interactive. So my name's Tom Franklin. I've practiced as a patent attorney in the U.S. for over 20 years. One of the biggest law firms in the world, with one of the biggest groups that do patent prosecution in the world. So I've kind of seen it all. For many, many different clients, I've gone through, restructured their portfolio or set up some sort of program to capture their IP. And after having done that, a dozen times or so, I decided to put together some software that made it a little bit easier. So Triangle IP, that's what we're about, is software that enables somebody, maybe just a business person or an executive or a technical person, to effectively manage a patent portfolio. To be able to answer questions like how much does it cost, how long is it going to take, what's the likelihood I'm going to get a patent, while having kind of standard workflow and nurturing and collaboration along the way. So we're in stealth mode right now. We're going to have a beta release in about a month. So please, if you're interested, let me or somebody know, and we'll make sure we get you signed up so you can try out the software. But with that, let me start on the program today, and I'm going to start with a poll question. And just to get an idea of where the audience is at. Have you done a lot of this, just a little bit, or almost none? And patent families, a patent family is just when you file a patent application, you might have foreign equivalents around it or similar cases that claim priority to it. So we call that a patent family. But just take a moment there in the software and answer this poll question. Okay, so with that, I'm going to jump right into the program. Why are patents important, right? Everybody has a different take on this. You may be pushed in it by an investor or maybe somebody on the board. But why people see such value here is that we're going into this information age, this knowledge economy, and the traditional sorts of protections that you have in this new age don't work, right? You can't put locks on the doors to protect your most valuable assets, your equipment or other hard assets when you're talking about intangibles. So patents, along with other IP tools, trademarks, copyrights, trade secrets, that sort of thing, are now these new locks for the knowledge economy. So if you're an investor, you want your companies to be filing patents so that there are assets that won't go away, right? As you may lose or gain employees, you may have products that are successful or orphaned, but the patents around them will leverage their value and also are a hard asset that can be bought, sold, used as collateral on a loan. And that's what generally IP does, is it takes something that's intangible, can't be owned, and if you can kind of fit it into a patent or one of these other IP tools, you will then have a hard asset, right? And folks like and can understand hard assets much more easily than they can just some idea, some vague intangible. So these intangibles, to the extent that you can protect them, will increase enterprise value, shareholder value, and that sort of thing. Another reason why you might care, the Patent Office, along with Harvard and some other universities, did the study, The Bright Side of Patents is a source of this, but they looked at companies that had issued patents versus companies that didn't, and the likelihood you would get VC funding increased by 57% if you had patents. They also found that the companies that were getting issued patents saw employee growth, they saw sales growth, and the converse was true also, right? When those didn't exist, they saw both of those things fall off. So, talk to somebody about strategy, particular to your situation. But certainly in the tech space, the life sciences space, chemistry, all these businesses that involve engineering or science to deliver products, patents are probably going to make sense. If you're doing some sort of business that's completely human performed, doesn't use software, there's no technology involved, maybe not, right? Patents really cover technology and not human performed activity. But presumably, if you're on this call already, you have a pretty good idea that patents are something you should be thinking about. So I'm not going to belabor that point. But there's certainly very good reasons to think about filing patents and developing a patent portfolio. So with that, I'm going to go to my next poll question. And what's the primary goal for your patents, right? You're on this call, you're listening to the video broadcast here, maybe at a later time. What is your primary goal, right? Because I find, we're going to get to strategy in a moment, is I can't devise a strategy unless I know what you're trying to accomplish, right? And big things are, if you're an established company, you might be trying to maintain your dominance, right? You've got premium products out there, but you're worried about upstart competition, perhaps coming out with something new that would displace you from that superior role you might have in the marketplace. So large companies are always worried about that, and that's why you see large companies end up being huge patent filers. And when they acquire companies, they're looking for companies that think similarly or might add to that arsenal of patents that they have. So big tech, absolutely in love with patents. Anything in the life sciences area, they want to see patents covering the products. Another big reason might be to prevent knockoffs. I mean, this is just kind of the straightforward use case is you come up with a product, you file a patent on it so that people can't copy that product. There's this expression that success breeds competition. As you release your product and people see that it's great, you're going to see others trying to copy your success, right? And patents will hedge against that sort of thing, is to the extent that your product is very important and significant, perhaps has high margin, is easy to produce, that sort of thing, people are going to want to copy you. And it's far easier to copy a winning formula than to do the trial and error associated with coming up with that winning formula. And that's why the patent system exists, is to incentivize those people that are reaching for the stars and trying to come up with new innovation. That's a very difficult prospect, but because we all benefit, might as well give those people a little bit of exclusivity so that they can recoup their R&D expenses. Another big reason why people think about patents is a hedge against competitor lawsuit. Let me explain what I mean by that. Is when you have no patents, people like to sue people, right? Especially in the U.S. But it's a way to kind of beat up on your competition. So when people are looking at weaponizing their patent portfolio to go after their competition, they worry about countersuit, right? If I go and drop a lawsuit on your doorstep, you're going to look through your patents and see if you can't reciprocate. So if you have a big patent portfolio, it ends up being a hedge against somebody pursuing that strategy. Is usually those bullies are trying to pick battles that they can clearly win, right? And if you have a patent portfolio, that's less likely to be the case. For early stage stuff, patents are really about attracting investment or valuation or acquisition, right? Depending on what your exit strategy might be. So I'll close out that poll question, and we'll go ahead and move to the next slide. So patent strategy. Patent strategy cannot be developed in the abstract. And what I mean by that is it requires, a lot of dialogue between you and your counsel. Because, patent counsel is a vendor just like any other vendor, and they have their own strategy on how to make money, and they have their own business model. And you want to make sure that it's your concerns that they're representing, right? So it has to be a bespoke, a customized approach that will deliver the most value. You have this tremendous expense associated with patent protection. Well, what's that worth to you? And that will kind of define what your value proposition is. So setting up the goals, letting your counsel know what your exit plan is, if any. Sometimes it's just simply go it alone, and perhaps we want to build up a patent portfolio commensurate with our positioning in the market, or our aspirations to be positioned in the market. Sometimes it's those questions that we had on the last slide, which is to hedge against competitor suit or attract investment, that exit plan. Those are all things that are very relevant when you're determining what you should do, right? Because your patent counsel, if they're just thinking about their business model, they should file as many patents as you can afford, right? But as you'll see in the next slide, it's quite expensive. So you can't really have an approach like that. You have to have a very measured approach. And certainly small enterprises, small and medium enterprises, you can't afford, a gold-plated, the best patent strategy out there. You'll very quickly spend far more money than it would be worth to you. So you have to have a measured approach, right? You have to consider where the litigation might be, which countries perhaps, if you're doing business in many countries, where your competitors are doing business, right? Where those lawsuits might happen. What's the likelihood you actually would do a lawsuit, or is it just simply to get patents to be acquired so that somebody else might worry about a lawsuit or something like that? So, cost becomes a huge issue. And if you talk to your average patent counsel, you'll say, I want to get a patent, and they'll say it's X dollars for me to write that up, right? And depending on the technology, if you look at the industry survey, it's somewhere between $8,500-ish for a mechanical innovation and $15,000 for a chemical innovation, with software and electronics being somewhere in the middle of that. So that's just the writing cost, but typically that's what you'll be quoted. And people will optimize that, right? As you might find somebody who will write a really inexpensive patent application, but you have to understand the broader context of that. is a very thin, narrow, uncreatively drafted patent application tends to churn excessively at the patent office. And then if you're filing that in multiple countries, you can then magnify that cost pretty quickly, so that saving $2,000 or $4,000 on the front end is really insignificant when you think about the whole process. So it's better to think about each patent as really committing to a multi-year process where you're talking about $30,000 to $50,000 US for each filing, right? And if you're doing multiple countries, again, 30 to 50K. So just in the US, you're talking about something that's really 3 times the writing costs. And that's pretty equally divided between writing costs, arguing costs, and then government fees. And the government fees come at filing, they come at issuance, they come after it's issued, various times as you're arguing it. But depending on the size of your country, your company in the U.S., there's discounts for micro entities, small entities, 500 employees or less, or large entities pay full price. But at any rate, those costs are rather significant, but they pay for the examination and all this sorts of stuff that the government agency, the patent office, does to make sure that your innovation is worthy of patent protection. So rather than thinking about the writing costs when you talk to your counsel, think about that whole big, long, multi-year process that's going to require input from you and continuing invoices for years and years and years to come, right? So if all goes well, you can expect to be paying maintenance fees, perhaps 15 years down the line, right? So you're committing to this ongoing process. Rounds of arguments there's more precise ways to break that down. They have particular names. You have a first office action, final office action, request for continuation, and stuff like that. All this jargon. But in essence, when you think about filing a case, you're going to have some number of rounds of argument where you will get some sort of rejection. In all likelihood, 85% of the time, a case gets rejected initially. And then your counsel will be tasked with perhaps amending the claims, perhaps arguing. I do a lot of meeting in person with examiners. I'm in Washington, D.C. today, and I met with an examiner on 2 different cases this morning to try and convince her that I had 2 different clients that I was arguing this morning that their innovation was worthy, or perhaps with this amendment, their innovation was worthy of a patent. But suffice to say, for each round, you're going to be into it for $3,000 to $5,000 on average. And it's not unusual to see 2 to 4 rounds of argument before your case gets allowed. And a lot of that depends on, whether your innovation was truly breakthrough, whether the examiner is tough or easy on average, whether your counsel is effective or ineffective on average. And that's one of the things that the Triangle software attempts to estimate, is to give you an idea that when you have a case, the examiner that I met with this morning, I have a bunch of cases with her, and her allowance rate is 75%, which is above averages at the patent office. But I'm meeting with an examiner later this week who has never allowed a case. She's been at the office several years and has not found anything worthy of allowance. Well, those 2 cases are going to be fundamentally different, and the cost footprint of those is going to be fundamentally different. I might have to argue with the examiner that doesn't like to or has never issued a patent, since she's been at the office for several years. I might have to argue that many more times than I would, for example, the examiner I met with this morning, right? So it's all different, but knowing that this is going to be an expensive case, this is going to be difficult to get, this one's going to be easy, that's key to maintaining that value proposition. And then when it comes to international strategies, costs get out of hand very quickly. And there are ways to try and get the maximum coverage for the minimum price, and working with your counsel to come up with that bespoke approach, because there is no universal patent. There is no patent that covers you worldwide, right? So with that, another poll question is, typically as I have that conversation, that all-in cost conversation, it's very surprising to people, right? So this poll is just given that, is that what you expected, or was that surprising? Just a little bit of feedback on that point before I move on to the final slide in this short presentation. So choosing counsel, right, is, I presume if you're listening to this webinar, you're very early in the process, or perhaps you're doing some soul searching with regard to your current counsel and wondering whether or not you're getting the most value. The cost, is it worth the cost, right? That basic value proposition. And here's where I'll say technical background matters. In my legal services business, we have 100 technical people that do patent prosecution. And to be licensed to do it in the US, you have to have a technical background. Well, is it the technical background that is good enough for your technology? So there's pretty simple kind of business method sorts of ideas that most people can understand. But what if your innovation is some sort of specific laser, or some sort of machine learning? The worst thing you can do is talk to somebody or hire somebody that doesn't understand your technology. Is going to have a difficult time, because at the end of the day, almost all counsel work on some sort of concept of hourly billing. So if you have somebody who's going to have a hard time understanding what your technology is about, it's just going to take more time, and more time means more money and means higher bills for you. So really knowing that you have somebody that might have the technical background, that you would be willing to hire them if they were an attorney or an agent, you would hire them within your enterprise. So they can pretty quickly come up to speed and draft a patent application that's creative and covers most of the interesting things you might try and seek protection on. And then make sure you have a counsel that will talk about these strategies, right, that are tailored to your enterprise. Doing that bespoke approach versus, some sort of strategy that favors their business model, which is file as many patents as possible, rather than thinking about it, right? Patent counsel tends to be more expensive than most lawyers, because it's about 50% more expensive per hour for these folks, because you're really paying for a specialized engineer. Like, imagine hiring a consultant as an engineer, and then you're paying for a lawyer on top of that. So the most expensive strategy is the one where you have no strategy. And you would be surprised. My practice of kind of reworking patent strategy for companies of all sizes, or developing these strategies, you'd be surprised. Some of the most well-regarded companies out there don't really have a strategy that makes any sense. And as we kind of pick through it, it's not uncommon for me to be able to take their patent spend and cut it in half while getting more coverage, because we're just much more focused about it. So you have to be able to talk with that counsel, understand their thought process. They ought to be able to talk at a level that you can understand, because you're paying per hour for them to go about doing that. So find somebody that can really frame it in a way that makes sense to you, so you're very comfortable committing to that spend. And then don't fall into the trap where someone will quote you a very low cost for writing a patent application. There's even software that's coming online that tries to use AI to write a patent application. In my experience, as I've tested out that software, is it writes a very bad patent application inexpensively. To do a good patent application requires people that are very well trained and have good mentoring and are very committed to quality. But it's hard to judge that not being an expert in this field. But besides restructuring patent procurement programs at companies, the other big thing that I do in my legal services practice is fix up bad work. And it's just astonishing how much bad work there is out there. And in a way, that patent firm makes more money because bad work requires lots of churning at the patent office. There's lots of rounds of argument, and that all quickly eclipses any sort of savings you had on the front end. So don't fall into that trap. And then ask for cost estimates, but ask for cost estimates for the full life cycle, not just the next step. And then part and parcel to that is try and figure out how likely you are to be successful. Like if you want to see, an attorney squirm, is ask them in a percentage way, what's the likelihood of success? Because they might say, I feel really good about this next round of argument. Well, that's very subjective. That might mean if you ask for a number, that might mean a 5% chance of success. By really good, they thought it could be 0, so 5% sounded pretty good to them. But 5% is different from 50% or 80% or 90%. So push for that number so you can sit there and figure out if the cost is worth it, right? Because if you have an examiner that has never allowed a case and has been at the office for a while or has a 10% allowance rate, that's fundamentally different than an examiner that has, for example, a 75% allowance rate. Well, only by knowing the difference between those two can you actually make a valid business decision. And that's a fair question. There are excellent tools. The Triangle IP tool has this too, where you can get statistics on the examiners, right? So that's completely fair to ask and really just a good part of managing this process. Think about the foreign costs. It's very easy now to file in many, many different countries. You can start off that process. But I've had so many clients that start down that road and then find out later that it's just gotten far too expensive. Because it's not uncommon to start spending more money overseas than you would, for example, in the US for your US patents. But then you have to sit there and say, where am I likely to litigate these? On a dollar basis, the US is the favorite place, and then maybe Germany next. And then China certainly has far more patent litigations than other places, but the dollar value is lower. But where is that litigation likely to occur? So if it's not likely to occur in a particular jurisdiction for whatever reason, there's not competitors there, the market isn't great, so the damage models aren't great, or it could be simply that the court system isn't respected enough with regard to enforcement that it's worth the hassle. But think all those things through, right? So that you can make a good buying decision. Because understanding the patent area is very, very difficult. It's crucial to your companies, yet it's very easy to end up with a no strategy approach that delivers very little value at tremendous cost. And it's shocking. It's shocking when I dig into these portfolios and look at what's been done in the past. And it just appears as though whoever's driving strategy, the expression is asleep at the wheel. It's just a listless approach, or perhaps a retread of what they've been doing before that goes on and on and on without any thought or any real engagement or any sort of contemplation of value. So it's all too prevalent. So with that's all we had on the content. We're trying to keep this this presentation to a half an hour. With that said, I'm happy to stick around and answer questions. I have one comment here on one of the questions that, that didn't quite have the answer that they wanted when they were answering the polling. So feel free to ask that question either in the chat window, and I'll stick around and go through any of those, or certainly offline. You can get my contact information and ask anything you want. But I'm happy to give you any advice either with regard to software tools or with regard to the delivery of legal services, right? With that, okay, so there's one question here. I'll switch over to the questions. So, question does not fit the answers. So I'm having a little bit of a technology problem. So just bear with me a second. Okay, so Hans has a question, how to build a valuable portfolio, just kind of in general, right? And, just like we were talking about strategy, before, it depends, right? Value depends on your particular circumstance, right? And it's different for everybody. So defining what your exit is, defining what your goals are, defining what your metrics are, will help you figure out whether or not you would build a valuable patent portfolio. So, not sure if that answered the question, or maybe it was just that the polling question was worded awkwardly. But at any rate, sitting down and going through that and what value is. And if anybody wants to talk to me offline, I'm happy to kind of go through what I think is value for your particular circumstance. But it's kind of asking those questions to figure out what the moving parts are, and then coming up with a solution that makes sense for your enterprise, right? Something that's where the cost is worth it for you so that you are getting delivered value. So hope that helps. If anybody has any other questions, I'm happy to take them offline. You can reach out. You can set up a call with me. Just reach out to the organizers for the seminar, and I can go through that, and I'm happy to spend a few minutes with you to answer particularized questions for your situation, right? So with that, I'll go ahead and sign off. Thank you so much for your attention, and expect more of these seminars. Thank you.